Today's presentation is taking the mystery out of wills. Next week, the next presentation will be October 27th. We will be presenting on occupational health and safety in the time of COVID-19. And on November 3rd, we will be presenting vaccines and the workplace. Where do we go from here? Today, I'm going to do a quick overview of estate planning. Then I will speak specifically about wills and give a general overview of what's involved in making a will. And then, with any time remaining, I will answer your questions. Now, everything that you hear today will be legal information, but not legal advice. So you should not rely on this as if you had hired me or any other lawyer to advise you specifically on your particular will. This information is for your consideration and for your general education, but should not be relied on as legal advice. Okay, so starting with an overview of estate planning. Estate planning can involve more than making a will. When you are planning your estate, you are making a plan for the disposition of all of the assets you own when you die. Now, by disposition, I mean you're making a plan for what's going to happen to these things when you're no longer around to enjoy them. And just to be clear, I'm going to use the term property to include everything that you might own. So rather than strictly interpreting property as real estate, real property, I mean your cars, your stamps, your coins, your air miles, your digital currency, cash you have in the bank, and your cottages, your condos, your houses, all of that falls under the general term property that I'm going to use. So when you're planning your estate, the first thing you might consider is making a gift while you're alive. Gifts can be made tax-free, generally speaking, and you get the added benefit of seeing the person to whom you're giving the gift enjoy the use of that gift while you were alive. Often you will see that referred to as an inter vivos gift. It's also possible to create trusts when you're making an estate plan. This is more common for high wealth individuals. Today's session is focused more on your regular folks, not your millionaires and billionaires who are trying to do some very, very elaborate plans starting while they're alive. Your estate plan can be affected by any domestic contract or separation agreement you might have made. These are also known as prenups, prenuptial agreements. And when you make a domestic contract or a separation agreement, it can govern what you can do with your property in the future. One way to pass benefits to your heirs or your intended beneficiaries is to make a beneficiary designation when you are signing pension paperwork or signing up for life insurance, signing up for a TFSA, an RRSP, an RRIF. Anytime you can designate a beneficiary, and the beneficiary will be the designated person to whom a benefit is paid when you die. that benefit gets paid directly to that named beneficiary. We refer to that as passing outside the estate. And we will come back to this later when we're talking about planning specifically as it relates to estate administration tax. There is sometimes some confusion between powers of attorney and wills. Powers of attorney are to be used while you are still alive. It's often necessary for people who start to experience diminished capacity later in life to have somebody in place to make decisions for them, to name a substitute decision maker in a power of attorney. You can make a power of attorney for personal care and a power of attorney for property. The power of attorney for personal care gives your substitute decision maker the ability to make decisions on your behalf with respect to your health care. The power of attorney for property gives a substitute decision maker the power to do everything that you can do with your property except make a new will. So that would include selling your house, mortgaging your house, opening a bank account, closing a bank account, advising or changing your investment strategies. Anything that you can do, they can do. So it can be an opportunity to make sure that your wishes are carried out, and it can be a complication depending on how well your attorney knows your wishes. That said, your attorney is bound by law to keep the best interests of the person who made that power of attorney in mind, and not to defeat any of the intentions set out in that person's will. Multiple wills can be made. It is common in Ontario for the person making a will, referred to legally as the testator, somebody making their last will and testament, to make more than one will. A primary will is made for the purpose of disposing all property that requires probate. A secondary will can be made for all property that doesn't require probate. Most commonly, this is a controlling interest or shares in a privately held Canadian corporation. So if you have a small business that you have incorporated, it is possible to pass those shares on to your heirs without the requirement of probate. And it has the additional benefit of making a disposition of those shares to somebody who you might feel will control the business better than your other heirs or beneficiaries. Now, specifically speaking about wills, I get a lot of calls about what will happen to the things you own if you don't make a will. So a common misconception is that the government will take everything if you don't make a will. That's not the case, generally speaking. If you don't have a will, then your heirs are determined according to statute. And the rules will generally dispose property to any spouse that survives you and any children that survive you in a predetermined fashion. If somebody dies without a will, without a spouse, and without children of their own, then the rules say that we have to trace through blood relations looking for the closest living relative, and that closest living relative then becomes the beneficiary of the estate. It can happen that somebody's wishes match exactly what would happen if they didn't make a will. And the question becomes, well, why would I make a will if that's what's going to happen anyway? And typically there are three benefits, even where you don't have any specific instructions that would change the statutorily prescribed distribution. One is the delay caused by an intestacy, intestacy being someone who dies without a testamentary document, without a will. There's a delay. Property that requires probate before it can be distributed can't be distributed until probate is complete. You're going to have to then figure out who the estate trustee will be. That estate trustee will have to go through all the steps necessary to making an application for probate. And then only once probate is returned will they be able to begin the administration of the estate. These days, it's not uncommon here in Toronto for the application for probate to take 6 months or longer to be processed by the estates court as a result of COVID and the extra steps in administrating wills and estates where people are working remotely and not always from the office. The second reason to make a will is that it removes any uncertainty or ambiguity from your intentions. The statute describes people by class, your children, your, perhaps we end up looking for nieces and nephews. We want to make sure that the intended beneficiaries get the benefit of your estate, and we don't want to have any uncertainty in determining who these people are. Lastly is the expense. The expense in administering an estate where there is no will is generally higher than administering an estate where there is a will. Okay, so I've been saying probate over and over again. Properly, it is now called a certificate of appointment of estate trustee with a will, or a certificate of appointment of estate trustee without a will. As you can imagine, we still say probate a lot. That's a mouthful. So the certificate of appointment of estate trustee is a certificate from the court which certifies that the estate trustee has been properly appointed. The certificate of appointment of estate trustee with a will comes with a copy of the will itself attached. This certificate is the proof that an estate trustee needs when dealing with any entity that requires proof of the estate trustee's authority to deal with the assets of the estate prior to turning over that asset to the control of the estate trustee. So for example, bank accounts. Where a deceased has left more than a minimal amount in a bank account, the bank will require probate. So once probate is granted, the estate trustee takes a copy of the certificate of appointment to the bank. The bank looks at the certificate, and that certificate is the bank's way of satisfying itself that it is right for the bank to give the estate trustee control of all the money in the account. It's the same thing for the land registry office, which controls land titles in Ontario. So if you have a house, if you have a cottage, if you have a condo, whatever your real estate holdings are, the land registry office won't complete the transfer of that property until the estate trustee has probate. If you have to apply for probate, you have to pay estate administration tax. Estate administration tax is currently payable on the value of the estate over $50,000 at a rate of 1.5%. In addition to paying estate administration tax, you should expect to have legal expenses for the legal advice an estate trustee will need in the administration of the estate. You should expect to have to pay an accountant to prepare income tax returns, which are necessary not only for the deceased up to the date of their death, but from that date forward until all of the assets of the estate are distributed to the beneficiaries. The estate itself is a taxable entity. When submitting probate, we submit the will along with an application by the estate trustee, an affidavit of execution of will signed by one of the witnesses to the will, proof of death, and proof that the estate trustee has given proper notice to the beneficiaries of the estate of their entitlement under the will. The affidavit of execution is often overlooked and is not necessarily always kept with the will in situations where people have collected their will from their lawyer that drafted the will and now keep it in a safe deposit box or at home, ideally somewhere safe. If you have your will, please check to make sure that you have your affidavit of execution as well. If you don't have your affidavit of execution, I strongly encourage you to follow up with the person that drafted your will and ask them to provide an affidavit of execution. This should be done at no additional cost. Estate administration taxes are the predominant consideration for people making a will. It should be considered in the context of other tax implications for the estate plan, such as income taxes, most commonly capital gains, or if we're dealing with small businesses, the exemptions to capital gains. For the purposes of our discussion, we'll limit it there, but it's important when making an estate plan to consider more than just reducing the estate's exposure to estate administration taxes. Reducing the estate's exposure to estate administration taxes is most commonly done by holding assets in such a way that they don't form part of the estate. So when I mentioned that the land registry office won't allow an estate trustee to deal with title to property until the estate trustee has probate. That is for property, or that is for real estate held solely in the name of the deceased. Where, for example, spouses hold title to their matrimonial home as joint tenants, then automatically, by right of survivorship, the surviving joint tenant becomes the sole owner of the house. Similarly, where bank accounts are jointly held, on the passing of the first of the joint account holders, the surviving joint account holder becomes the sole owner of that account. Anytime an asset passes directly to a surviving owner, we consider it as having passed outside the estate. It passes outside the estate because it doesn't require the involvement of the estate trustee or any will or any other, in the case of intestacy, any other rule about dealing with assets, because when you hold something jointly, the right of survivorship is the rule that we follow. People will then often consider holding assets jointly with their children or other intended beneficiaries. This is an appropriate strategy in some, but not all circumstances. And again, I encourage you to take specific advice from a lawyer about your particular circumstances before deciding whether or not you should hold property jointly with anybody except your spouse. There are special circumstances that arise when title to real estate has been converted from the old registry system to the land title system. And without going into too many specifics here, I just want to note that it is possible in certain circumstances for real estate held solely by a joint or held solely by a deceased to be passed to the beneficiaries without probate. And that is a first dealings exemption. Essentially, the first time that title to the property has been dealt with since its conversion from registry to land titles. When making a will, you have to be at least 18 years old. You have to provide valid ID, at least to any lawyer who's going to draft your will. You have to have the capacity to make a will, meaning you have to understand the nature and effect of the will itself. You have to have an understanding of what you're doing and why you're doing it. Specifically, because you are disposing of all of the property that you have to have knowledge of that property. When I take will instructions from somebody, we go through a very extensive survey of everything they own. And it's not imperative that we have figures down to the exact penny for how much you've got in the bank or what your house is worth. But it's important for me to see that when we're making your will, you have a very full grasp of what you own. There are some red flags that we watch out for when we are meeting with people and taking their instructions. Capacity, as I just discussed. If we get the sense that the person giving the instructions for their will doesn't really understand what's going on, then we've got to dig deeper into whether or not the person truly has the capacity to make a will. A capacity challenge is one tactic that somebody who feels left out of a will or snubbed or otherwise doesn't like what's in a will. A capacity challenge is one way somebody in that position will try to have the will thrown out, in effect. Other common challenges to wills are situations where there is undue influence or duress. So undue influence looks like somebody who is named as a beneficiary in the will has pressured the will maker, the testator, into amending, changing, adding somebody to a will. Any of these situations where somebody in close contact with a bit of influence over the person making the will may have had too much input or any input at all into what ultimately ends up in the will. So in situations where a parent is living with one of their children and that child is providing care or otherwise uh, very much in control of their parents' circumstances. The more dependent the parent on the child, uh, the more scrutiny, special treatment of that child in the will attract. Now, duress would be a situation, again, where there is pressure, where somebody is being forced. So, if a parent was living with a child and it was the case that the child was saying, you've got to change your will, you've got to give me more in the will, or else, I'm kicking you out of the house, or I'm leaving and I'm not taking care of you anymore. That's duress, that's pressure. Any of these circumstances will vitiate a will result in a will being invalid. Even the appearance of these things can lead to significant problems. In situations where we have an estranged child who is left out of the will, that estranged child can challenge the will even where there hasn't been undue influence or duress, if that's the way it looks from the outside. What most, well, not most commonly, what is common is that even an unsubstantiated claim by that estranged child who is not included in the will, their claim will get settled because it will be cheaper to pay off that disgruntled, estranged child than taking this before the courts and everybody paying for lawyers at the expense of the estate. So it is best where we have the involvement of children in a parent's life to take whatever steps we can to satisfy ourselves that there is no undue influence or duress or the appearance of it, and to make sure from a lawyer's perspective that we have carefully noted these things in our file, so that if there should ever be a challenge, we could refer to the notes of that lawyer and we could snuff out any claims quickly and thoroughly. Okay, let's talk about making the will itself. When you're making a will, in addition to deciding who will be the beneficiaries of your estate, you have the opportunity to appoint guardians for minor children and make it clear to your estate trustees any non-binding wishes you have that you might want to include in your will. When you appoint a guardian for minors, that appointment lasts for 90 days, at which point the guardians will have to make an application to the court to be appointed guardians for those minors. Non-binding wishes, these are often instructions for funeral, memorial, burial, cremation, anything that your estate trustee might not otherwise know. It is a good idea to collect all of your documents that your estate trustee might need into one place and make sure your estate trustee is aware of where you keep those documents. These would be life insurance policies, pensions, bank statements, investment statements, any contracts you might have for a prearranged memorial service, or if you've already bought a plot to the cemetery, these sorts of things. You could also include current addresses for your beneficiaries and anything else that might be specific to your estate. I'm going to focus on making a complete disposition of your property. So the purpose of the will is to make sure that everything you have is delivered, or is addressed in your will, with the result that it will be delivered to your intended beneficiary. Let's first of all review the types of gifts you can make. You can make a gift of specific property. For example, my mother's wedding ring to my niece, let's say. That is a specific item, the wedding ring, to a specific person, my niece. I could also make a cash gift. I could say, I want to give my niece $5,000. And in that case, I've specifically set out the amount, and I have specifically stated who the beneficiary is. This is often a way that people will donate back to their church or to their preferred charities, hospitals, or people who they want to recognize, perhaps distant relatives who they want to recognize or leave a small gift to. It is also possible to leave gifts to classes of people rather than specific individuals. So, rather than leaving my mother's ring to my niece Adeline, I might say, I would like to leave $5,000 to each of my nieces and nephews. And in that way, even though I don't know exactly how many nieces and nephews I might have in the future, given that my brothers and sisters are going to possibly continue having children after the date I make the will, I will be sure that I haven't excluded any niece or nephew born in the future. Because we don't know exactly what the situation will be at the time of passing, we can't know exactly how much we're going to have to give away. So we make gifts of specific property, wedding rings, a car, the cottage, say. Then I give out some cash gifts, 5,000 to my church, 5,000 to the hospital, 5,000 to my best friend's son, say. And then whatever's left over forms the residue of your estate, that pool of assets that gets turned into cash and distributed. Residual beneficiaries, people who benefit from the residue of your estate, get percentages or shares of your estate. That avoids the problem of trying to say exactly how much goes to each. One thing to consider when you're making your plan, if you have, say, an estate worth $100,000 and you have specified cash gifts in excess of $100,000. So, if I give $50,000 to my to each niece, and I have 3 nieces, I've given away a total of $150,000. And then I say the residue to be divided amongst my children in equal shares. The order the will is read is gifts of specific property first, and then cash gifts, and then residue. So if after paying out your cash gifts, there's nothing left in the residue, then your residual beneficiaries won't actually get anything from your estate. In a case where you've given out $150,000 and there is only $100,000 to distribute, that amount gets prorated, so each would get 1/3 of $100,000 in my little example there. Now, the general rule is it's your money. You can do with it what you want. In your will, you can give your property to anybody you like, but there are exceptions. Your spouse has rights. You can't give your spouse any less than the amount to which they would be, well, let me rephrase. If you give your spouse any less than the amount they would be entitled to in a divorce, your spouse has the option to claim under the family law rules the amount they would have received if you had divorced the second before you died. So you have to provide for your spouse because one way or another, your spouse is entitled to a portion of your estate. You also have to provide for any dependents. Now, this can be minors, children still living at home. This can be adult dependent children. And this can be anybody else towards whom you have shown a settled intent to provide for. So if you've taken somebody into your home and they are now dependent on you for their well-being, they will have a claim against your estate if they are not provided for in your will. I want to make a specific note about charities. Some people choose to give to charities a lump sum, a specific amount with cash. Some people choose to make their preferred charity or charities residual beneficiaries. In other words, they get a share or a percentage of the assets of the estate. A word of caution about making a charity a residual beneficiary. Charities hire lawyers to make sure that the charity receives every penny to which it might be entitled, which often raises the burden on your estate trustee because your estate trustee will experience much more scrutiny. Now, maybe that's a good thing. Maybe all estate trustees should have to account for every penny and every expense and every amount received by the estate. However, the amount of work involved in going to that level of detail is often more than is required in a small or modest estate, and is often more than an estate trustee is comfortable taking on. So if you make a charity the recipient of a gift of a specified amount, for example here, $10,000, as soon as that charity receives its $10,000 gift, it can no longer question the actions of the estate trustee. On the other hand, if the charity is to receive 10% of the estate, it will make sure that it receives everything, receives 10% of the maximum amount to which it is entitled. This often leads to challenges of the amount of compensation claimed by estate trustees, and often results in greater accounting expenses for the estate, and can have the follow-on effect of paying lawyers and accountants out of the assets of the estate rather than paying that amount to the intended beneficiaries. When leaving a benefit for somebody who needs help managing money, or somebody who is receiving Ontario Disability Support Program payments, it is a good idea to consider creating a trust for that person. Um, for somebody on ODSP, the trust that we create in a will has the benefit of not disentitling them from receiving ODSP benefits. This is often referred to as Henson Trust. But there are other trusts that can be created in your will. And the specifics, again, are something that you should speak to a lawyer about when drafting your particular will. I just mentioned these here in passing, in case that's something that you want to discuss with your lawyer when it's time to make a will. I mentioned earlier the job of the estate trustee. It is not a privilege. It is a job. Estate trustees' compensation is considered income and taxable as such by the CRA. And it is most commonly advisable for estate trustees to have an accountant prepare all the necessary employment forms to make sure that the estate trustee's employment by the estate or income paid by the estate is properly recognized. The estate trustee is personally liable for the payment of income taxes and other debts of the estate. Not all. It depends on the debts of a particular estate. And the compensation to which they are entitled is not always set in stone. It's possible to state in your will exactly what compensation an estate trustee is entitled to, but it's more common for an estate trustee to claim estate trustee's compensation based on the formula that has been developed by the court through common law. That amount is often the subject of scrutiny and can lead to disputes between beneficiaries, especially sophisticated beneficiaries such as charities, and the estate trustees. Generally speaking, when choosing an estate trustee, if you have one beneficiary of the estate and that beneficiary is capable, I would appoint that beneficiary as the estate trustee. If your beneficiaries are, say for example, you leave your estate to your spouse, and if your spouse passes away before you, then to your children in equal shares, you may want to choose all of your children out of some sort of recognition of fairness or equality. But again, it's not a privilege to be an estate trustee. And the estate trustee is liable to the beneficiaries in addition to being personally liable for income taxes and debts. Now, that liability to the beneficiaries creates an opportunity for the beneficiaries to review the actions of the estate trustee. So if you have 3 children, it's not necessary that you appoint all 3 children. The person that you choose, the child that you choose, will be accountable to the other children and will have to show what has been done by the estate trustee and a complete set of finances, accounting reports will have to be provided to the estate beneficiaries. However, it does also entitle the estate trustee to compensation, which can lead to an unequal distribution of the assets of the estate. So sometimes there are benefits to naming only one of multiple beneficiaries, specifically the speed with which the estate can be administered. Anytime that something needs to be signed or any time there's a meeting, it doesn't require that all 3 beneficiaries attend. On the other hand, it can lead to an unequal distribution. As with everything that we're talking about today, it is best to review the specific circumstances of your estate with the lawyer who is drafting your will and making your estate plan with you. Okay, so these are now opportunities for conflict. These are situations that I just want to make you aware of because this is where a lot of the problems arise when beneficiaries get a chance to see a will and start to figure out, whether or not they think what's happened is fair and whether they're going to challenge a will. So as we discussed earlier, involvement of others in the will making process. If you're going to an appointment with your lawyer and one of your children drives you, one of your children comes into the meeting with you, one of your children speaks for you when you're asked a question, these are red flags. These are situations that can lead to will challenges. If you need a translator, it is best to get somebody who is professionally employed to provide that service, rather than, say, a child who is comfortable speaking both the language of the lawyer and the language of the testator. Blended families can create problems. If we have, a couple each on their second marriage and each with children from a previous marriage, there can be tough decisions to make about who will be the beneficiary of each of the spouses' wills, especially when we take into consideration that after one spouse passes away, the other might change their will. Common law spouses do not have the same rights at law as married spouses, especially where there is no will. So it is important when making a will to have considered the effects of your particular spousal arrangement, whether it is married or common law or other, as I'm sure if it's not possible yet, it will be in the future. Being separated and not divorced can create opportunities for conflict because until a marriage is terminated, especially in situations where there is no will, a married, a separated but not divorced spouse will still have rights to the estate. Estranged children, as I touched on earlier, can have can create problems with your intended estate plan, and especially where all of the circumstances surrounding the testator's choice to disinherit an estranged child have been documented. Persons born outside of marriage, there are differing feelings on whether an adopted child, a child born out of wedlock, the children of those children, there are differing opinions on how people who fit that description should be treated as opposed to strict blood relatives, if you will. An unequal division of assets amongst people who feel they are on equal footing, for example, children, can create conflict. We've touched on that a bit, and given that we are quickly approaching 1 o'clock, I'll just move on to the next one. Donative intent. If you have held an account at the bank jointly with one of your children, but not all, the question will be, is that person holding that account in trust for all of the beneficiaries of the estate, all of the siblings, or was it the intent that surviving child should get use of all of the money in that joint bank account alone or exclusively for their own use. Loans to and from beneficiaries. Where you have made a loan to a child so that they can buy a house, but you haven't made a similar loan to another child. How is that loan to be treated? How is that loan to be repaid? Business interests. Again, if you're in business for yourself, if you are operating a corporation or own shares in a corporation, it is best to deal with those items specifically rather than leaving them generally to your estate trustee to sort out. And the cottage, almost always a problem because when somebody owns a cottage on their own, there's no questions about who gets to use it when, and who's responsible for paying the taxes and paying for the repairs. But as soon as you hand that cottage down to more than one person, are those beneficiaries to be joint tenants? Are those beneficiaries to be tenants in common? Tenants in common create separate legal interests in the property. What happens if one of those people with a separate legal interest wants to sell? What happens if they want to give their share down to their children when they pass away, and so on and so forth? And we can end up with 14 different owners of a cottage who don't know who's to pay for repairs or taxes or who gets to use it. Working with a lawyer. We'll skip over this pretty quickly. Your lawyer will go through certain steps. Generally, these are the ones outlined here. Nothing too important, I would say, for you to know at this time. I'm sure as soon as you retain a lawyer and start work on your will, you will go through these steps. Storing your will. We offer to store anybody who makes their will with us, we offer to store their will at no charge to them in our fire resistant cabinet in a locked and secure location. This has the benefit of ensuring that the will won't be modified in the future or lost or damaged. Some people like to keep their will in their safe deposit box. This can create a bit of an issue at the bank because the bank's not sure about who has access to the safe deposit box, and until they read the will, they're not sure who has access. But anyway, a little bit of a circular problem that we have to solve there. And then if you keep your will at home, it can be damaged or lost, or sadly, sometimes we see people who are starting to experience a bit of a loss in their mental faculties will start to write physically on their will. They'll want to make changes, or they'll try to remove somebody that they don't want to give assets to anymore, and they can end up inadvertently invalidating their will, which is a situation that we would certainly like to avoid. Quickly, I want to mention that these future acts should affect your estate plan. If you get divorced, obviously, it's time to make a new will. If you get married, your will is automatically invalid. It's time to make a new will. People are born, people die, people change their names. You might experience a significant change in financial position and want to avoid that situation we discussed earlier where all of your specific gifts or your cash gifts are paid out and there's nothing left for your residual beneficiaries. And then the general passage of time. If 10 years go by and you haven't reviewed your will, it's probably time to review your will just to make sure that you're happy with what's in there. Okay, so we've got a few minutes left. I see that 2 questions have come in. Let me just look here at the questions. First one, what are the considerations when there is property across jurisdictions? For example, the cottage in Quebec. So That is the jurisdiction by jurisdiction determination. Whether a will made in Ontario will be respected in another jurisdiction depends on the laws of that jurisdiction, and whether or not the assets governed by the will be taxable, or whether there will be any other levies against the estate, again, depend on that jurisdiction. The best advice I can give you, being a lawyer, let me rephrase that. The best information I can give you, we're not giving legal advice today, the best information I can give you is to ensure that you have consulted with a lawyer licensed to practice law in that jurisdiction, so that you have advice as to how your property in that jurisdiction will be treated under your will, or in the event you don't make a will, what would happen in those circumstances. And in some jurisdictions, it is best practices to make a separate will specifically dealing with the property in that jurisdiction. How should digital assets be accounted for in a will? When we're talking about personal accounts, the passwords for those accounts can be included in that package of important documents that you're going to provide to your estate trustee. For assets of monetary value, digital currencies, for example, those are assets that will form part of your estate, and they will have to be properly valued and transferred to your beneficiaries. For things such as email accounts, or your social media accounts, that is not strictly speaking the subject matter of a will, but you may have wishes that you want to communicate to your estate trustee about what should happen to those accounts. The next question is, when you have life insurance, does that go to your estate to pay off bills first and then to the beneficiaries? That will depend on whether or not you have designated beneficiaries of the policy itself. If the estate is the beneficiary of the policy, or if you fail to designate a beneficiary, in which case the estate is automatically the beneficiary of the policy, that amount will be paid to the estate, and the obligation of the estate is to pay off all bills and expenses, just debts of the estate, before any distribution of the assets. So it's necessary to pay income taxes, any property taxes in arrears, any other debts owed at the time of death that can be proven or of which the estate trustee is aware. All of those need to be paid off first before any of the beneficiaries can receive any money. And it looks like we've got one last question here. Must a will be notarized to be effective? Or can an individual write their own will and just have a witness sign it? When you write your own will in your own handwriting, that's referred to a holograph will. The best information I can give you is don't make a holograph will. When you make a will with a lawyer, you have the benefit of knowing that that will be prepared in proper form. You don't have that guarantee with the holograph will. You don't know, even though you write out what you say is your will, you don't know that it will be recognized by the court as the authentic last will and testament of the deceased. When you make a will with a lawyer, it doesn't have to be notarized. It has to be witnessed by two people. Neither of those people can be a beneficiary of the estate or a relative of the beneficiary of the estate. Again, when you deal with a lawyer, it's assumed that that lawyer is not family and not a beneficiary, nor will the other witness be. And so your witnesses will be valid. The other benefit of making a will with a lawyer is if it turns out the will is not properly prepared, liability for that falls on the lawyer who drafted the will. And it's not the case where the person who handwrote their will and it turned out not to be valid is left without a will or without recourse. Added benefit of having a lawyer prepare the will, you can sue the lawyer. And on that note, I think we're going to wrap up. That is all of the questions we have today. Thanks for coming to the free webinar series, our Back to School with Eilert Campbell LLP. Again, October 27th, you can join us for occupational health and safety in the time of COVID-19. And on November 3rd, you can join us for vaccines in the workplace. Where do we go from here? Thank you to everybody who attended today. If you have any questions that I wasn't able to answer, I can be reached by the details on the Eilert Campbell website. Have a nice day, everybody.